And welcome back. In this segment, we're going to discuss two issues that we've already spoken about this hour as they converge in one particular incident. I'm talking about grand juries and also holding police accountable, and how both of those, they came into play in the tragic death of Daniel Prude last year. Prude, as you may remember, died after police in upstate New York had to use force to arrest him, putting a hood over his head and pressing his face into the pavement. They responded to a call about a naked man running in the street and yelling that he had had COVID, and they say restraining him was the only option at the time available to them. The medical examiner determined that Prude's death was caused because of several factors, including oxygen deprivation as well as PCP drug intoxication. Now, several officers, they were suspended after the incident, and then Attorney General Letitia James convened a grand jury. But none of the officers wound up getting indicted, and James said afterwards that she was disappointed by the outcome. Now, grand juries are by nature very secretive, but the transcripts to this one, they were released to the public, and they paint, well, let's just say a complex picture. The analysis by the New York Times says that attorneys in the AG's office presented both sides of the case, which is unusual as prosecutors usually present just one side in hopes of securing an indictment. They also called witnesses that both defended the officers and those who said that they used unreasonable force. At least one juror says that they were confused and struggled to reconcile the contradictory testimony. Well, my next guest co-wrote that piece in the Times, staff writer Sarah Maslin Nir. She joins us now. And I got to admit, I thought it was fascinating, the reporting, but I'm even more confused than when I started with this. We've all heard the expression, you know, you can indict a ham sandwich when talking about it. But are the rules different for police, or are they unwritten rules that the Attorney General chose to follow in putting up both sides when she was only required to put up hers?
Well, when the ham sandwich is a police officer, you have very different outcomes. 1,000 people are killed a year in the United States at the hand of police officers. Only about a third of those officers are ever indicted, and a small proportion of those lead to a trial and conviction. So it's a different beast when an officer is involved. And that's because of a number of reasons. But one of the largest is that officers are allowed to use a measure of force in their job. You and I can't restrain anyone, but officers have to. So there is wide leeway given when officers do use force. And also, jurors tend to give police credence. They don't necessarily side with them, but they are more understanding of what it takes to do their job and often rule in favor of them. But when these cases with grand juries involve something as thorny and involute as a police officer using force, it is not that unusual for prosecutors to really throw everything at the wall and see what sticks. And that's what happened here. Prosecutors from Tish James' office, they used many different witnesses. As you said, one said, definitely, these guys used exactly what they were trained to do, and there was no misuse of force. And another wasn't so sure. And in those secret transcripts that were revealed, unusually at James's request, actually, you see the jurors struggling to reconcile the two. And this was used almost as a testing ground to see what would happen in trial. How would juries react to multiple sides of information?
So you hit on a couple of things that I'm still at a loss for. One is, when I was finished with the piece, I was wondering, well, how did these grand jury records get out? Letitia James chose to put them out. And she also chose, when there wasn't a decision by the grand jury to indict, that she said she was disappointed, extremely disappointed. Well, if she was extremely disappointed, why did she choose the witness list that you just described that would imperil at least an indictment to get to the trial phase? So I guess it could be one of two answers. One is at least the public face, that you say, well, you know what, this is what a grand jury is supposed to be. It's supposed to give a complete picture to the jurors so they can make up their mind. Or more practically, that's not what usually happens. Was this just a different choice in a selective one because it was cops at the grand jury phase?
Well, we asked those same questions of Ms. James, and she granted us an interview because, especially to advocates in Rochester who've really wanted justice for Daniel Prude, and to them, that looks like a conviction for the officers that effectuated his death. those words of extreme disappointment rang extremely hollow. Exactly what you said. One of the people that James called to the stand was an officer who actually later went on, excuse me, an expert who later went on to say he probably wouldn't have convicted Chauvin in George Floyd's case. And actually, the attorney general has said those subsequent words would have made her rethink the choice of him. But he's a known police defender. And yet, Ms. James, in our interview, said, we set out to present information and figure out if there were charges that could be brought here. Ultimately, she said, following that 45-hour exhaustive investigation before the grand jury, thousands of pages of which were released, they felt they could have brought charges. And she did feel she would have been successful at trial had the jury decided to indict these officers. That didn't happen.
You know, in your reporting, you spoke to a lawyer for one of the officers that also was given the opportunity to testify before the grand jury, which was a choice by the prosecutors. Michael Shiano, an attorney for one of the officers, he said, prosecutors put on the case that we would have put on anyway. They put on the witnesses we would have put on if there was a jury trial. I guess what I'm trying to get my arms around, Sarah, is, was this completely irregular, what happened in Rochester, or is this the norm when a cop's on trial at the grand jury phase?
Well, that's super hard to answer because of the very nature of grand jury proceedings. They're secretive. They are not required to release them, unlike almost every other type of trial and situation involving the courts, which are in this country public. Grand jury proceedings are secret. So we don't have a lot of basis for comparison. However, my colleague Nicole Hong and I spoke to experts who have testified on these cases all over the country, and they said it's not that unusual for a multiplicity of perspectives to be presented when it's an officer. And it's a special circumstance because, again, the law shows that officers are permitted use of force in the course of their duties. Actually, right before our story came out, James proposed legislation that would sharply curtail or delineate what does use of force mean. Right now, it's an amorphous word that gives officers a lot of permission. And so she said, until the law changed and makes this a little bit of a more curtailed use of force, you're going to keep running into what she ran into in this case.
Well, it's a fascinating look behind the curtain, if you will. Sarah Nir, appreciate a few minutes. Thank you so much.
Thank you.
All right, everybody, we're going to take a quick break. When we come back, we'll wrap things up.